These are the submissions for the respondent. Mr. Kithi, counsel for the defense, submitted that the application was not properly before court and did not meet the threshold as it does not bear the official stamp of the court. He submitted that there was no oath before court, as the affidavit before court was not signed by the deponent and that it was not dated, and as such, and that it was not intended to be used in this application as it did not indicate. And the same is indicating that it was an application, an affidavit to oppose bond, and yet the accused had not been charged. He further submitted that the application was not properly before court, as Section 28 of the Public Health Act, under which the application is brought, does not give court powers to entertain such an application as the one before it. It was his submission that the applicant is not clear on which orders they wanted from court. The applicant was not clear as to whether they want the respondent held in isolation or to facilitate investigations. He submitted that the respondent had not taken plea and therefore cannot be held in prison facility. It was his submission that the court has no jurisdiction to commit someone who has not been charged to prison or correctional facility. He further submitted that even if the respondent was to be held for 14 days to facilitate investigations, then he cannot be held in a prison facility. He further submitted that there was no need to curtail the freedom of the respondent, as he is not a flight risk, and that the respondent was not going to leave the jurisdiction of the court, as the whole world is grounded, and there were no flights leaving the country, and therefore there was nowhere the respondent will run to. Counsel submitted that the respondent was put through medical tests and examination at the Coast General Hospital, which tests purportedly turned negative. However, upon being it was his submissions that the respondent was tested on 23rd of March this year, 26th of March this year, and 31st of March this year, and the results turned negative from COVID-19. The question that this court seeks to answer is whether or not omission to have the supporting affidavit dated amounts to procedural technicality. In attempt to define what amounts to procedural technicality, Justice Marete, in the case of James Mangeli Moso versus Ezetech Limited, 2014 EKL, stated as follows: a technicality to me is a provision of law or procedure that inhibits or limits the direction of pleadings, proceedings, and even decisions on court matters. Undue regard to technicalities therefore means that the court should deal and direct itself without undue consideration of any laws, rules, and procedures that are technical and or procedural in nature. Lastly, I wish to note that the application herein was brought under the wrong provisions of the law. Section 28 of the Act, under which the application was brought, has nothing to do with isolation of patients. The section deals with the penalty for exposure of infected persons and things. The relevant section ought to have been Section 27 of the Act. In conclusion, having considered the application, the supporting affidavit, the submissions, the relevant provisions of the law, and the international instruments applicable herein, it is my finding that the reasons given by the applicant do not warrant this court to place the respondent in isolation at the Manyani GK prison. It is my finding that the application dated 6th day of April this year lacks merit, and the same is dismissed with costs. Republic versus Gideon Edmond Saburi. Who is present for the Republic?
Anasema sijamwona, lakini anasema juzi alikuwa
Magolo, are you in this matter?
No, we are waiting for Madam Nyoroke. Well, thank you so much for stating, at least at this level, the law. This directive, I basically read as much as I can see. It doesn't state where, basically, the order, summary, submission, they do not.
And indeed, as the State Council put it, it's clear that the document that has been presented before court, I've gone through it. It indicates that His Excellency the President was speaking to journalists from our vernacular radio station. We are not privy as to who did the translation and as to whether what is contained in the document before court is actually the exact position as to what transpired. So I may not be in a position to comment on that because I'm not sure if what is there is the exact position. The truthfulness of the document is in question. Secondly, as to the DPP, Mr. Haji, whether it is true or not true that he has made comments on the matter, but in any event, counsel for the defense and the accused, the judiciary is an independent arm of the government, and matters are dealt with and determined based on the evidence adduced, taking into account the facts presented before court and the law. The judiciary cannot therefore be directed on how to handle a matter. This matter shall be procedurally dealt with, and based on the evidence that shall be adduced, a proper and justifiable verdict shall be reached by the judicial officer who shall handle the matter without fear or favor of any intimidation. There's no need for the defense to panic. And lastly, since this matter is now properly before court, I urge all Kenyans to observe the sub judice rule, desist from making any comments in respect to this matter as to its merits or demerits. This is a matter that is live before court. Let the court deal with this matter without being perceived that it is under any duress on how to handle the matter.
14. Paka, is it 15? Okay, 15. Tuesday, next week Tuesday. Nataka tuone background ya court.